Good evening. My name is Faisal Al-Khatib, and I have with me
Damon Rittenhouse.
Damon Rittenhouse and myself are here to you from Better Informed Housing. We are an organization that is building the future, saving the community, and helping the neighbors in terms of providing education to the community about housing issues. So Damon is here today to talk about the Keeping Chicago Renting Ordinance. Thanks for coming, Damon.
Pleasure to be here, Faisal. Thanks for having me.
Briefly, Better Informed Housing Corporation is located at 218 North Jefferson, Suite 103, Chicago, Illinois, 60661. You can reach us at 312-533-2688. And our website is betterinformed.org, and you can email us at neighbors@betterinformed.org, providing education information to communities about real estate. So today we're talking about the Keeping Chicago Renting Ordinance. Damon, tell me a little bit, where does this apply and why is this important?
So Faisal, the Keep Chicago Renting Ordinance, it's also known as the KCRO. I think I'll refer to it that way. That's the shorthand, the acronym. It's been around in Chicago now, I think, for about 3 years, and it was drafted as a response to the foreclosure crisis that hit Chicago very hard, starting in about 2008, 2009, and it's still having some of the after effects that are felt today. And it's really designed to protect people who are tenants, renters in properties that go into foreclosure. And the city council decided that they wanted to have protections for those people because they were oftentimes being victimized when their landlord got foreclosed on. They would end up losing their home as well, even though they hadn't done anything wrong and they were making their rental payments like they were supposed to.
So just to understand, so essentially this is where renters who are living in buildings or properties or units or condos or homes where there's a landlord and the landlord has gone into foreclosure. So the tenant's not in foreclosure, but the landlord is.
Exactly, and that's a good distinction to make. It's for people who have leases that are renters, and obviously there's a lot of those people in Chicago. It's to protect them when their landlord, the owner of the property, gets into foreclosure. They get behind with the bank and they lose the property through the court process.
Now, if I read this properly, this is kind of crazy. Essentially, if you have a legitimate lease, and I know you're going to go into that,
Sure.
But technically, if I'm a tenant and I live in a building and the landlord goes into foreclosure, I can make like $10,000-$20,000 if the bank doesn't follow this law. Can you explain a little bit about that?
Absolutely. And the important thing to keep in mind is not necessarily looking at it as an opportunity to make money per se, but it's really designed to protect people and their interests and help them either maintain their lease and stay at the property and not lose their home as long as they're making rental payments, or they can receive up to $10,600 in relocation assistance.
Oh, wow. Okay.
So it's critical. I would advise any tenant to do this to keep good records. You want to have a written lease if possible. Even if it's a month to month, any kind of documentation you can have about your lease agreement and the payments that you've been making is going to be very important, because if you have to go to court, you want to be able to prove that you are what's called a bona fide tenant, meaning that you actually do have a lease agreement, you have the right to be there, and that you've been holding up your end of the bargain, and now, unfortunately, the property's in foreclosure, and you'd like to exercise your rights under the KCRO.
Does the lease have to be written? What if I don't have a written lease?
It doesn't have to be written. Like I said, if having a lease in writing is ideal if you can do it, but a lot of folks for various reasons have an oral lease. It goes month to month, and that's okay. It doesn't mean that you can't be covered under the KCRO. It can just be a little more difficult maybe to prove what your status is, but what's really important is tracking those payments. So even if you don't have a written lease agreement, if you have copies of canceled checks, even if you have to pay with cash for whatever reason, making sure you get written receipts from your landlord is very important when it comes time to trying to prove that you are a tenant.
So if I'm what if I'm depositing the cash or giving the cash into their bank account or depositing to the landlord-tenant bank account? I mean, I've had situations where, clients of mine who are tenants, they're depositing the checks or the cash directly into the landlord's bank account. What do we do in that regard? I mean, if we don't have cash receipts?
Sure. I mean, the advice I would give to people if they're tenants right now, before this has even become an issue with foreclosure, is try to get written records, receipts, whatever you can from your landlord. I think there's really no reason a landlord shouldn't want to give you a record of the payments that you made. If that hasn't happened and you find yourself in a situation where you're in foreclosure, There may be an ability to subpoena those bank records, bring that landlord into court and have them testify. there are legal mechanisms that can be used. So no matter what your situation is, if you have been making those payments, it's important to talk to a lawyer and figure out what your options are. Just because you don't have the canceled checks or the written lease agreement doesn't mean that you're completely out of luck. It just might be a little more challenging to prove your case.
So stay on my landlord's good side then if I want to get the relocation assistance or protect my lease.
I think it's always helpful to have a good relationship with your landlord. What we've seen a lot of times is when tenants come in, they either haven't heard from their landlord in a while or their landlord has left Chicago. And a lot of times their landlord was in financial trouble and these folks had no idea. So they thought they had a good relationship with the landlord, and maybe they did, but their landlord was not keeping them fully informed about the status of the property, and he or she may be difficult to locate right now.
So so in this case, should a person keep making their rent payments if the landlord's in foreclosure? Doesn't that mean that the bank has taken the property from them?
This is where it gets a little tricky, and part of it is understanding the whole foreclosure process as well. So like I mentioned, some people who are tenants don't find out that a property is in foreclosure until after it's been sold and they get a notice from the new purchaser. Other times people find out the property is in foreclosure and the foreclosure process can last for a year or 2 years or 3 years, and they're not sure who to make their payments to. That's again where it's important to talk to a lawyer if you're at that point in the game and figure out what your legal rights are. With the KCRO, in talking to people who are at that point in the game, usually the property's already been lost and it's been sold. If you find out the property's just started the foreclosure process and you're still living there, that's a little bit different, and it's good to get advice on how to proceed there and how to protect yourself even before the property's sold.
Can I still be evicted if the landlord is in foreclosure?
You should not be able to be evicted while the foreclosure case is going on in court. Where it gets a little bit tricky is, can you be evicted after your landlord has lost the property in a foreclosure sale? The short answer is not immediately. You're entitled to get notices, you're entitled to be served and have due process and have your day in court. And again, like anything else, when you get information that the property is in foreclosure or that it's been sold, it's really important to go talk to a lawyer immediately so that you don't fall behind or things happen against you in court that can't be undone.
And you mean, so I can still, if my landlord is in foreclosure and I don't pay the rent, my landlord can't evict me?
Your landlord might be able to evict you while a foreclosure case is pending against him or her.
Okay.
And again, that's a little bit different thing to discuss. The KCRO is for people who are at the end of the foreclosure process. I think what you're talking about is people's rights while the foreclosure is pending, and those are really important too. So if you're a tenant that finds out that your landlord is in foreclosure but the property hasn't been sold yet, it's also important to go talk to a lawyer and find out, do I have to keep paying my rent while this foreclosure is pending? Legally, the answer is usually yes, but you don't want to just keep making payments if you're not sure how that's going to affect your status. So again, it's good to get advice about that before things happen too far one way or the other.
So I still have to keep making my rental payments to the landlord?
The landlord is technically the owner of the property until a foreclosure sale is confirmed. So all things being equal, he or she can still demand those rental payments from you,
Okay.
even if they're not paying the bank. So it's important to find out exactly how to proceed because each case is a little bit different. But I would never advise people to just stop making the payments without having a very specific plan in place or having an understanding about what's going to happen going forward, because then they might get evicted by their landlord who's in foreclosure, and he or she would have the right at least to file that lawsuit.
Gotcha. So they could go after me for non-payment of rent, irrespective, have nothing to do with the foreclosure, but because I haven't paid the rent to the landlord can come after me. So keep paying my rent to the landlord if I can find them, right?
Correct.
And then the next piece is when the foreclosure is finished. So really the KCRO applies to after the foreclosure is done is what you're saying.
Correct.
And so now the bank or the seller at the sheriff's sale or some other buyer who took the property, they have to protect me pursuant to the Keeping Chicago Renting Ordinance.
Exactly. So that's a good distinction to make. And again, the sooner people find out that the property they live in is in foreclosure, oftentimes the better it can be. So I would never advise people to just wait until a sale happens or they're contacted by a third-party purchaser. I think it's smart to try to have a plan in place as early as you can.
Beforehand.
But certainly if you are contacted by someone on behalf of a bank or another entity that has purchased a property, that's when you really don't want to hesitate and you want to get in and talk to a lawyer and bring your lease agreement, bring any of that proof of payment, and let the attorney know exactly what's going on and make sure that no deadlines have been missed, make sure that if a court case has been filed that attorney understands that they need to represent you in court potentially to make sure that you're protected under the act and that you get what you deserve.
So should I leave if my landlord's in foreclosure? Should I just stay, or what? I mean, what should I?
It really depends on each individual situation. I would say you don't have to leave if you're in foreclosure. To your point earlier.
My landlord's in foreclosure.
Or yeah, the landlord. I'm sorry. Yeah, the landlord is in foreclosure. The property's in foreclosure. It doesn't mean that you automatically have to leave. It also doesn't automatically mean you should stop making rental payments to your landlord. So again, it's important to speak with an attorney and get an understanding of what your rights are and what your specific situation is and what's best for you and your family.
So what are the different pieces that are required? So when my landlord's in foreclosure, I'm still making my rent payments to the landlord, and then I get notice the property's been sold, and I get a letter or something from a bank or the bank's attorney saying it's time. I have to show that I'm a tenant, or I mean, what information specifically should I have? And can you number them for me, please?
Sure. I think the main thing that you'll want to have is some proof of your tenancy. And again, the most common thing would be a written lease agreement. Not everybody has that. So from there, it would be some statement that you had an oral lease, that it was month to month. Whatever the circumstances were between you and your landlord, you'd want to be able to explain that and then prove it with documents as best you can. And usually that's going to be proof of payment if you're able to obtain that.
Would an affidavit work that says, hey, I swear that I have a lease in this and I'm living here?
If that's all you have, I would say that's where you would want to start.
Okay.
It depends on the circumstances if that's ultimately going to be enough to get you the relocation assistance or prove your position in court. But if that's all you have, I think that's what you would need to submit, whether it be to a real estate agent who's reaching out to you, it could be an attorney who's calling or emailing or sending you a letter on behalf of the third-party purchaser. You don't want to ignore that notice, whether that be a letter that you get or whether it be a summons to come to court. You don't want to ignore it. You want to get together whatever information you have, and you certainly want to make your attorney aware of what's going on so he or she can advise you, here's how we need to proceed.
Now, what would an attorney charge me for this stuff? If they have to charge me, is there a fee, or how would that work?
Well, it really depends, because sometimes it's just going to be negotiating a settlement and getting you money maybe to move out, or perhaps extending your lease if that's something that the third party is interested in. Other times it might be defending you in an eviction case because they might not send you those notices, they might not work with you, they may just try to find out who you are and get an order of possession against you and have the sheriff come out and evict you. So in that instance, there could be a court case where an attorney would need to go in and appear on your behalf and file things in court to protect your interest.
If they don't send me the proper notices and they do what you just said, does that help me in terms of the keeping? Is that a violation of Chicago?
That is a violation of the act, and that's something that would probably be brought up by the lawyer either to defend against an eviction case or maybe as a lawsuit against that bank where the tenant is the plaintiff and seeking damages because they didn't do what they were supposed to do.
So then in that case, who would pay my attorney if there was a violation of the KCRO?
The KCRO does allow for what's called fee shifting. So if you can win your case, the party that you sue, in this case it would be a bank or a third-party purchaser, would be responsible for your attorney's fees if you can show that a violation occurred. So it may be that if you come to an attorney and he or she understands how the act works, they may take your case on what's called a contingency basis, and you don't have to pay them much of anything up front, and they understand that if they're successful, that fees can be had from the bank or from this entity that didn't do what they were supposed to do pursuant to the act.
So then if they made a mistake pursuant to the act and we can prove that, essentially we're looking at the violation of the $10,600, whatever the case may be, plus attorney's fees?
If you're successful, yes, you can get damages under the act for violation as well as attorney's fees and costs of the lawsuit that it took to bring that to the court's attention and to make right what went wrong.
Now, is it just the $10,000, or is it actually twice the amount?
I think there is a provision in the KCRO that says if you can prove there was a violation, you may be entitled to damages double the $10,600. So,
wow. So $22,000 or $21,000.
Yeah, close to $22,000. So that's why it's important to understand what your rights are under the act, and if there is a violation, to take very quick action on it, because what you don't want to have happen is that this isn't brought to the court's attention quickly enough and you lose the ability to protect yourself, protect your rights, and get the money that you're entitled to, especially if there's a violation.
So is there a close time frame in terms of what's the timing as to when the sale takes place? Is there a certain time period
So there are various notice requirements under
Thank you, notice
the Act.
requirements.
Yeah, and I believe the requirement is that as a tenant, you're supposed to be notified in writing within, I believe, 30 days.
21.
It's actually only 3 weeks then, so that's a little bit shorter, that there has been a change in ownership of the property, and basically it needs to seek information from the tenant about who they are, what their status is, all those things I mentioned earlier, and that's where a written lease would come into play, proof of payments over the last at least 12 months, if not longer. And if they're doing things right, meaning this new third party, they'll work with you from there once they can identify who you are and figure out what your status is. So it's important to be looking for those notices, and if they're sent, to follow up with them, and if for some reason they're not, to make sure that you understand that that's a violation and to move forward from there.
And so we want to go to quickly let you know, we are the Better Informed Housing Corporation. We're an Illinois nonprofit providing education information to communities about real estate. You can call us. Our phone number is 312-533-2688, or email us at neighbors@betterinformed.org. Our web address is www.betterinformed.org. You can call us today at the number below your screen at 312-738-1060. We are live. Again, my name is Faisal Al-Khatib, and this is Damon Rittenhouse, and we're here to talk about the Keeping Chicago Renting Ordinance. So you're talking about the notice provision. So there's 21 days they have to let us know that there's a new owner. Now we've got, if I'm reading this properly, we've got 21 days as the tenant to respond back as to what our decision is whether you want to move forward.
Correct.
Can the landlord raise my rent? Can they take it, like if rent I'm paying $1,000, if the tenant's paying $1,000 a month, can the landlord say now you have to pay $2,000 a month, or is there an issue with that?
There would be an issue with that, and it's one thing to keep in mind in our experience is that usually when these third parties are coming in and have purchased the property, they're not generally interested in allowing tenants to stay and renew their lease, but if they are, they're only allowed to raise the rent up to 102% of what the rent was. So in your example, if you were paying $1,000, I think the highest they'd be able to make it is $1,020 the next year. They would not be able to raise it to $1,500 or $2,000. So if you do have a new purchaser who's willing to work with you and you're interested in staying in the property, you may be able to work out a lease extension. That is one provision of the act that's allowed, and rent control is part of that. Much more common in our experience is that whomever has bought this property is just interested in getting people out.
Okay.
And if so, that's fine, but if they're going to do that, then they need to be willing to pay the $10,600 under the act. This is assuming they're following all the rules and they're sending the notice. And it's important that if you get that notice, you need to respond quickly so you don't give up any rights under the act.
Okay.
And that you're doing everything you need to do to prove your status and to make yourself available and entitled to the funds, the relocation funds.
Now, we talked about briefly, you said something about a bona fide tenant. Does that, I'm presuming that means that you're not related to the landlord in any way? Is that how that works?
A big part of it is making sure that you actually had the right to be there, that you were a legitimate tenant, that landlords who own this property, who got in foreclosure, didn't just make sham leases with brothers, with uncles, with cousins, in order to try to bilk money out of these third-party purchasers. So it's important that any lease agreement that is put forward is actually legitimate, that it was made between you and the landlord as part of a legitimate business deal, and that it wasn't some con game that was put together by a landlord who's in foreclosure. It's also important to make sure that it's not between someone who's squatting there, who never was entitled to be there in the first place. So the family relationship with the previous owner is important, but it's also to make sure that it's someone who was there pursuant to a real lease that was making actual money, legitimate market payments. Not someone who was
before
paying
the foreclosure.
Before the foreclosure, exactly.
But before the foreclosure, I'm like, what if I start renting from a place that's already in foreclosure?
That depends. Usually, before a sale is confirmed, an owner, in this case the landlord, would have the right to enter into a lease agreement with a tenant, and it should still be considered valid. But again, it's important to make sure that it's not with a family member and that it's not for much less than what market rate would be.
Okay.
So to use your example of $1,000 rent, if you put forward a lease agreement, even if it's not with a family member, but if it's with somebody else and it's for $250 a month, there's a good chance a court would look at that and say, this is not fair market value, this lease is not valid. So it's important that your lease agreement can show that you had a legitimate lease, that it was for fair market value, and that rental payment was being made, at least within a reasonable time before the foreclosure was ended.
And by the circle, in terms of where that circle is with regards to family, is that, and if I'm reading right, it's parents, children, and siblings, right? So I can't have a lease with my parent, mother or father. I can't have a lease with my sibling, brother or sister, and I can't have a lease with my children. If the lease is with those three, that is not considered a bona fide lease according to the ordinance. Correct?
Yeah. So, and just to clarify, people can make those types of leases if they want to. So we're not saying those leases are invalid under any circumstances, but if you're attempting to get protection under the KCRO and get that relocation assistance, you can't use a lease that's between a family member. So I just wanted to clarify.
But a brother-in-law or my cousin Shirley, totally okay.
That part is a little bit unclear.
Okay.
The language in the act really focuses on closer family relationships. So it's if you have that type of a situation, like always, talk to your lawyer about it. Bring it to court, see what happens. I think the further removed you get, the better argument you have that that's actually a bona fide lease. But the act isn't completely 100% clear. Can there be any family relationship? Can it be a friend? That's where it's going to get a little bit of a case-by-case situation. But what the act is really trying to avoid is landlords who are in trouble making deals with people that are getting some kind of benefit from this. They want to make sure it's a legitimate lease, what's called an arm's length transaction, and go from there. So each case is going to be a little bit different, but the best thing you can do is get in and talk to your attorney quickly and explain what the circumstances of your case are, and then that lawyer can figure out how to move it forward from there.
And this really stemmed from, at the beginning of the crisis, if I'm not mistaken, and correct me, Damon, was when banks were foreclosing on large buildings, just buildings in general, and doing mass evictions and throwing out tenants without any compensation, and the tenants really had no control, no protection from getting evicted by the banks, and that's where the Keeping Chicago Renting Ordinance came in.
That's exactly correct. The city council, I think, heard many, many stories, and we've dealt with a lot of clients who have been in that situation where their landlord lost the property in foreclosure. They didn't know about it. They've been making their rental payments. Some of these people have been living in these properties for years, and then very unceremoniously, they were getting eviction notices, sometimes letters, sometimes they were actually being sued in court, but there was very rarely any offer of relocation assistance, and most often there was no communication at all. It was just either get out or we're going to get a court order and we're going to put you out.
And now they're protected by this. They're protected by this ordinance that was passed a couple of years ago. So the last question that I have, I just want to make sure, is that if my landlord is in foreclosure and they're suing my landlord, am I liable for any money? Can they come after me for my landlord not paying his mortgage?
No, because you're not a party to that mortgage contract. So at that point, it's between the bank and your landlord for any kind of monetary damages. Your only connection is the lease you have with the landlord. And to Faisal's point earlier about making payments while a foreclosure is still pending, that's why it technically is still important to do that, because you may have liability to your landlord through your lease agreement, but you won't have any liability to the bank because of the foreclosure. You're not a party to that loan, and almost never are tenants actually named in the foreclosure, even as defendants. The bank or whomever buys has to bring a separate action or name them independently in a different court and make sure their rights are protected.
So even if they name the tenant in the foreclosure, if I'm a tenant, for example, even if they name the tenant in the foreclosure or they name the tenant in the eviction, they're not really going after money. What they're going after is possession.
Absolutely, that's correct.
Well, Damon, thank you very much for very informed information about the Keeping Chicago Renting Ordinance. I learned a lot, and I'm glad to hear that our tenants are being protected in the city of Chicago here. Again, we're Better Informed Housing Corporation. You can reach the number here at 312-738-1060. And you can reach Better Informed Housing Corporation, an Illinois nonprofit providing education, information to communities about real estate. For more information, you can call them at 312-533-2688, or you can go to the website at www.betterinformed.org. Damon, thank you again, and thank you all for watching.
Thanks for having me.
Have a good night.